So I think that basically enhances the skill of a particular individual, as well as leads to protecting that technology, or I would say the service or the product that you're planning to basically protect. So I really want to share my screen with you guys. So I hope you guys can see my screen.
Yes, sir, it is visible.
Great. So we will start with the basics of IP. In brief, I will let you know. I think most of you are aware of now that what is IP, what is patents, what is trademarks, what is copyrights. So we will briefly discuss about all those things, and after that we will cover why do we need patents, what is a patent, why do we need patent filings, what is the process whenever you come up with us with the invention disclosure, because even we have worked with a lot of individuals from your organization, from your university as well. So definitely we can have a discussion on that front. And after that, even in case if you have any questions, feel free to discuss with me in between as well. So shall we start?
Yes, please, sir, go ahead.
Okay. So so if we talk about IP, I really want to be an interactive session. So I think most of you are aware of that. What is IP? So any property which is belonging to a particular person, if it is related to technical improvement or any improvement in the art, literature, science, and technology, is an IP. So in day-to-day life, there are a lot of things, there are a lot of problems that we face, and we think that I think this should have the simplified version. So even that is an idea. So for protecting something, there is patent to protect that idea. Even you have not practically done that, even if you have not have enough arrangement in your campus, or I would say enough arrangement on your own as well. So don't worry about that, because patent doesn't say patent doesn't say that it should be patent doesn't say that it should be. Just a second. Yeah, so patent doesn't say that it should be practically implemented. You can do that once you have it. So it's important to protect that idea whenever you have. And as ma'am said in the beginning, that ideas can be copied, can be used by someone else, can be taken by someone else. So in order to protect that, we come into the picture where we can assist you, what improvement you can do, how you can do that, and how we can protect it. So in brief, this, if you have something related to prior knowledge plus human innovation, leads to evolution of that technology. So I think you can see in my diagram figure in the slide that there's a wheel, then we invented bicycle, then cart, and then car. So in this way, there is an improvement. So this is the evolution of technology. So the most important thing that I really want to emphasize on this slide, why do we need IPR? So I think most of the people ask me that what are the rights we are getting it from? We are spending a lot of money on filing. We're spending a lot of money on drafting part of application. So what would be the rights we will have? First would be economic rights, and second would be moral rights. If I say economic rights, it means that you will have that monetary advantages. Once your patent is granted, your trademark is registered, no one else in the industry, if in India, can use that without your permission. For that, they have to take permission from you, That is, they have to license it from you, or they have to buy it from you. And you can basically claim that monetary advantages from them. So your IP is your asset, and you have to protect it in order to get the advantages of that. Moral rights is nothing like that is your patent, no one can take it without your permission. And definitely that technology belongs to you if it has been granted. So, importance of IP to protect piracy, counterfeiting, and theft of an idea. IP drives economic growth and competitiveness. As I told you, that it will help you monetary in terms of monetary. Strong and enforced IP protect consumers and families. IP helps generate breakthrough solutions to global challenges. Definitely. This is a key point where definitely the improvement in technologies really help in getting the solution for the global respect, right? Earlier, there is no AI or machine learning technologies, but now it is getting used and getting trained in real time and giving benefit in all the sectors, I would say, in health, in gadgets, in automobiles. So it has a lot of advantages. IP rights encourage innovation and reward entrepreneurs. So this is a tree where that is related to IP. Patents, I think most of you are aware of that. Trademarks, if you have any brand name, brand logo, and that needs protections, then it should be protected under trademarks. Then there are copyrights, industrial designs, like if you have some mechanical design which is very particular, and design is important for that. So in that case, you should protect that. Geographical indications is related to origin of that thing from that area. For example, dazzling tea. So it has that origin. So geographical indication has their own advantages. And semiconductor chipset design is related to chips, ICs, integrated circuits. So can anyone tell me why do we need patent? It's an interactive session. I think most of you are aware of that. What is patent? Can you hear me, guys? So, hello.
Anji sir, Anji.
Can you hear me, guys?
Sorry.
Can you hear me?
Yes, you are audible, sir.
So I think most of you are aware of that. Patent is exclusive right that is granted for a particular invention, whether it is product, process, a new way of doing something, and offers a technical solution to that problem. And it has 20 years of validity. You can see that that is a sample of US patent application. When it is granted, it has, this is the first phase of that. Copyright. So any artistic work and any literary work, so that it should not get be replicated, or in order to avoid illegal duplication, we should protect that. And I think most of you are aware of that. There are novels which are being used by film producers, and without their permission, they can't do that. So in that, copyright comes into the picture. Copyright can be registered automatically, but yes, you will only have the monetary benefit once you will register it with the copyright office, that is with government. Otherwise, you will not have that monetary benefits for that economic rights. Any doubts so far? Hello, any doubt?
No, sir, no, please go ahead.
Okay, So I think this is a basic procedure of registering a copyright. Moving ahead, trademarks. I think you must are aware of that. Trademark is a sign that basically individualizes the goods of a given enterprise and distinguish them from the goods of its competitors. So as you can see. So as I said, the way patents gives rights to individuals and exclude others from using it, trademarks is the same way. So I can see that a trademark should be distinctive, should not be deceptive. It should not mislead someone about certain characteristics or a product. So you have to make sure that your trademark should be unique. Otherwise, you will get an objection. Geographical indication, as I told you, Darjeeling tea, Kanchipuram silk, champagne, they are originated from this place and they have that geographical associated with them. So no one else can take it from them. Trade secret, I think everyone is aware of Coca-Cola stuff, that they have a trade secret, and those trade secrets are being protected under this IP service. Industrial design, like design of a shoe. Most of the manufacturer related to sports shoes, they basically design their patent under this. So guys, so how do we file patents? How do we file trademarks? So whenever you come up with some idea, just not jot it down and share that with us. In that way, the basic step that we usually follow is that we first perform search to basically ensure whether that idea is novel or not, that is unique or new, is something new or unique is there in that or not. So sometimes ideas are being copied. So that is not patentable unless and until there is some improvement in that from the previous ideas, which are already in the public domain. So this is the reason we have to ensure that that idea is novel. In that, we use our paid databases, Orbit, Derwent, Patshare, to ensure that whether that technology is new or not, that idea is new or not, by running key strings. We pair key strings with their operators and check whether the invention is patentable or not. Based on the analysis or based on the search, we will share our analysis with you, that with the client, I would say, that whether this idea can be protected or not. After that, we will tell you that these are the features of your idea is not new, and this is the feature of the idea is new. So we have to integrate and think in the right direction to basically cover the new things, new features in that invention. So based on that, we proceed with the drafting of the same. As per the Indian laws, we draft all the forms and we draft all the applications as per the Indian law. The most important part are the claims. So I tell you. So these are the three parameters that we usually check while performing search: whether it is novel, whether it should be non-obvious, and it should be useful. Industrial applicability. In India, industrial applicability is very important aspect, because whether it is user-friendly and helpful for the customers or not. So we have to ensure that it should be. So the idea or the patentable subject matter should have these three features: novel, non-obvious, and the usefulness. So usually patent offers exclusionary rights. When I say exclusionary rights, so it has, let's consider an example here, which says that a patent is granted to a company A for a device embedded in a laptop computer that reduces power consumption in the laptop, right? So if there is a patent, does the patent permit the company A to manufacture and start selling the laptop with the embedded device? No, because a separate patent license might be required if the laptop or any other essential component is protected by someone else. It means, like, if you are if you are basically, company here has device embedded in a laptop computer. This is a device which is being new, not the entire laptop. And the laptop has a lot of components which is being manufactured by different vendors. So they have their own rights. And if you try to basically say that those laptop with that embedding device is mine, then company I can't take that. Only that device can be sold under their brand name and under that patent. Similarly, does the patent A permit the company A to stop laptop manufacturers to use the same technology as claimed in a patent? Yes, because that technology is new. That technology is basically defined by company A. So definitely in that scenario, company A can stop others from using that technology, but cannot stop others from selling that laptop integrated with that. Any questions so far? Any doubt? So what cannot be patented and what can be patented, and what are the prior arts, and what are the major things that we usually do when we receive an idea disclosure from your side. So these are the literature and non-literature search we conduct at our end to check whether your idea is patentable or not. So what cannot be patented? So anything related to, if you are playing with nature, if you're playing with laws, so that cannot be protected. That Newton's law of motion cannot be changed. It has been defined and you are not doing any improvement in that. So that cannot be protected. So anything available in nature, anything that goes against the laws of nature, an abstract theory, any mathematical formula, any straightforward algorithm, those cannot be protected. But if I talk about algorithms, their logic can be protected, because definitely under each and every algorithm, there is a logic, and those logic can be protected. So your patent should be categorized under these four categories. That is process, that is the method how it can be done. Machine, that is an apparatus. An article of manufacture, and composition. Composition usually comes in life sciences patents, biotech domain. Article is considered mostly in like design stuff. Machines are apparatus where we claiming that big machines which has a unique features and which has unique functionality, and and how, what is the functionality and how the process being taken while using those machines is comes under process. So I think life cycle of a patent, I think most of you are aware of that. First, there is an idea conception. Then there is patentability assessment. Then the most important stage, that is drafting and filing of patent application. Because if your application is not drafted well and you have left out some important information while drafting it, then it will backfire you during prosecution. When I say prosecution, means that when the examiner will review your application and if you miss something and you will say that, sir, I need to add this thing at this point of time, then you can't do it. You can't change the stuff after drafting and filing of that patent application. After within 18 months, it will get published, and then there is prosecution office action. During examination stage, there is one examination report being issued, and based on that, response will need to be prepared technically to convince the examiner that that our invention is unique and the objections that you're stating is totally different. Based on that, there would be hearing, and after that, there will be grant and rejection, and after that, there will be maintenance fees. So as you can say that the term period is from the filing date, from the expiry date is 20 years, and the patent application is enforceable only after the grant date. So this is not like there is Indian patent filing that I think most of you are aware of that, and we already discussed about that. And also, if anyone wants to file in not in India and then in US, and the invention is too good and they really want to go ahead with that, the US application, and then there are routes for that. You can directly go to US via Paris Convention route, And if they and they really don't want to file that in India. For example, a person filed an application in India, and now if he feels that he really wants to go to US, then within 12 months he can go there through Paris Convention, and in that we can assist you. In that scenario, we should inform Indian government that we are planning to go to foreign country, and we will file foreign filing license from them. Similarly, there is PCT route, another is PCT route. The difference between Paris Convention and the PCT route is that in here, even whenever we want to go to other country, we have 12 months from the date of filing of Indian application in India. But in PCT, there is 31 months. So we will have time. So the patent application includes a lot of stuff. There are a lot of sections. Background section is very important, which describes what is being disclosed in the prior art or in the public domain. Summary includes the gist of your invention. What is the crux of your invention? What is the thing you are solving in that? Along with the objectives and advantages of that. How is it applicable in industry? How is it user friendly and cost effective for humans? Then drawing section. Drawings, brief description of drawing describes that what is your system diagram states, what is your flowchart states. And then the entire section is description is related to the detailed, where we have to describe each and everything related to your claimed invention in the claims that is being protected in claims, the advantages, the scenarios, the specs, all those things. And abstract is also a general gist of your invention. So different types of patents can be protected, that is utility, plants, and design patents. Utility patents are 20 years, plant patents is also 20 years validity, and design patent has 14 years. So as you can see, these are the paid databases that we usually use, and also some databases that are publicly available to you guys as well. Whenever you check your invention, you can check on Google Patents to check whether their idea can be protected or not. So I think in that you can basically protect your, you can check whether your idea is new or not. Even if you're not sending it to us or any other IP firm, then you can check it yourself through these Google Patents, that what type of patent exists in your technology domain on which you are working. Similarly, eSpaceNet is there. Even that is free of cost. There is no charges for that. IP India, free patents online, patent scope WIPO. This is for US patent search. This is for Chinese. This is for Japanese and Korean. This is for Google Scholar. This is CiteSeer, that is for non-patent literature, articles and all those things. IEEE Explorer, I think most of you are aware of that. Same, that is ip.com. Science Directory is for journals, articles, publishing articles, and all those articles which are in public domain. ACM Digital Library, you can access those NPL, non-patent literature, from these sites. So that's it from the basics of IP and how we protect patents and how do we file those. For filing for the universities, I think nowadays it's getting a lot of hype. The reason being the fees has been reduced substantially. It has only 1,600 filing fees, almost 80 to 90% fees has been reduced. So most of the patents which are being filed at a university or by the individual inventors can be filed easily without thinking about too much cost. And similarly, if you talk about if I talk about design patents, even those are very cheap, $1,000 for design patent fees for an individual. And if I talk about university, then it would be 4,000. So in all these scenarios, whether it is patents, trademarks, we usually perform search and check whether that idea or mark is new or not. Based on that, we share those analyses with you guys, and based on that, we start drafting those applications for those ideas and grants. And after that, we file it. Then there will be prosecution, and based on the result of the examiner, then there will be grant or rejection. So, any question related to anything related to patent filing, design filing, trademark filing?
Students, you may ask your questions if you have any query related to how you can go for university patents. Please ask sir. He would be very supportive, and he would be able feel good to answer your queries. Please ask your queries. Please raise your hand. We'll unmute you so that you can ask the question. Aryan, please unmute yourself. So
All
Aryan
right.
has asked the so you can ask the question yourself.
Yeah, hello, sir. Am I audible?
Yes.
All right. So my question is like in India, basically, when a person files a patent, then we receive some emails in the spam box stating that you need to protect this patent on international grounds as well. Let's say German patent, Australian patent. So how to approach those type of patents on those international platforms, and is it really worth it, or should we go with Indian patents only?
So for that, we need to check first what is the scope of your invention. If I say scope, then we have to check whether this invention is being patentable in India or not. If it is good and can be carried out and can be filed in other jurisdictions, then we should think about it, because you can understand that other jurisdictions are too costly in patent filing. We have to pay 1200 1500 USD fees. If I talk about Germany, it is too costly. So in order to decide whether to go to that jurisdiction or not, we can do that. There is a straightforward process that you cannot do it on your own. That in that you need your help. You need our help, where we have dedicated attorneys in those jurisdictions in UK, Canada, Germany, EU, where